Welcome to Chapter 9. Let's think about how criminal cases end at the trial court level. In this chapter, we'll address the courtroom work group, the many phases of plea bargaining and courtroom work groups, and forms of punishment. We'll also address penalties and sentencing decisions, the fairness of sentencing, the severity of the penalty, sentencing guidelines, and the death penalty. The courtroom work group is an underlying order to the courtroom where the prosecutors, the defense attorneys, the judges working in a courtroom all work together as one group. The actors are regular and interdependent, and they share common goals and work together. The courtroom work group encourages cooperation. It's contrasted with normal thinking about courtrooms as places of conflict. It results in expectations such as normal penalties, unwritten, agreed-upon sentences that are considered appropriate given the manner in which the crimes were committed. It results in a group consensus about the meaning of justice. Guilty pleas are common. Plea bargaining is the process through which a defendant pleads guilty to a criminal charge with the expectation of receiving some consideration from the state for his plea. While not new, plea bargaining continues to cause controversy. Table 9.1 shows the steps of the criminal process from plea bargaining to capital punishment. What are types of plea agreements? Well, plea bargaining encompasses a wide range of practice. There's charge bargaining, where defendants plead guilty to a less serious charge than the one originally specified. There's count bargaining, where defendant pleads guilty to only one criminal charge as opposed to multiple charges. And there's sentence bargaining, where the defendant pleads guilty on the basis of the promise of a specific sentence. Table 9.1 shows us trial rates for felony defendants by most serious charge. You can see that murder charges are the most serious and most common of trial rates. Plea bargaining varies widely across courts, but there are similarities and important considerations to include, such as the seriousness of the offense, the defendant's criminal record, and the strength of the prosecutor's case. Why cases go to trial? Well, cases go to trial when the parties cannot settle on an outcome. They go to trial based on two primary factors: the strength of the prosecutor's case and the severity of the possible penalty. The courtroom work group works together in plea bargaining, but plea bargaining cannot be explained just by focusing on caseload. An increasing caseload approach to explaining bargaining suggests that courtroom actors are machines, more cases, more bargaining. Plea bargaining is a result instead of the shared norms by the members of the courtroom work group about how to handle certain defendants. In cases that survive initial screening, courtroom actors assume a high degree of defendant guilt. There is a tendency for participants to assume guilt and to focus their energy instead on how best to negotiate a plea bargain to avoid the time and the cost of a trial. Trials are costly, and trials are time-consuming. Trials present uncertainty for all the participants involved. All members of the courtroom work group have a common interest in avoiding trial, which is a rational response to the risks of trial. The costs of a jury trial in particular are high for everyone, but especially for the government, such as the jurors and the judge and the prosecutor and the clerk. If a defendant moves a case forward which other members of the courtroom work group believe should be settled, a penalty might result. Some empirical evidence supports this claim. Historically, however, guilty pleas were informal matters. Today, the process is much more structured. Realization that a plea of guilty is a waiver of fundamental rights, the presumption of innocence, a jury trial, and confrontation of witnesses. A plea of nolo contendere means that I will not contest it is a guilty plea, but not an admission of guilt. Judges may even refuse pleas when plea bargaining occurs. Let's think now about forms of punishment. Common forms of punishment include imprisonment, probation, and fines. More than 6.5 million adults are under some type of correctional supervision in the United States. Judges must choose the punishment that fits the crime. The United States relies on imprisonment more than any other Western nation, with greater than 1.5 million inmates currently. The number of inmates has tripled during the past 3 decades. Few prisoners serve their maximum term, and parole is the conditional release of an inmate from prison after a portion of the term has been served. This chart shows the increase in adult correctional population from 1985 to 2013. Good time is days off a sentence given to prisoners for good behavior and participating in prison educational programs. The length of imprisonment depends primarily on criteria used by parole boards, method used by correctional officials to compute good time, and the number of people on parole continues to increase, currently over 775,000 persons on parole. What is probation? Well, the principal alternative to imprisonment is probation. It's granted to more than 60% of criminal offenders. Probation is designed to maintain control over offenders while permitting them to live in the community under supervision. It's supported on two grounds. Prisons are inappropriate places for some offenders, and it's a less expensive way than imprisonment. Fines are one of the oldest and widely used forms of punishment. Fines generate over $1 billion a year for local governments, and they're often used in conjunction with other types of sanction. Let's think now about normal penalties and sentencing. Sentencing is a joint decision-making exercise where judges make the decision, but all members of the courtroom work group are involved. Probation officers play a role as well. They conduct pre-sentence investigations, which often include recommendation for an appropriate sentence. Each defendant and crime are different, but the work group seeks to standardize sentencing using normal penalties factoring include seriousness of the offense and prior record of the defendant. This table shows you sentences imposed after felony convictions. The most serious factor in setting normal penalties is the seriousness of the offense. Most courts employ a rank ordering of offenses going from the most serious, such as rape and armed robbery, to the less serious offenses. The defendant's prior record is also important in determining the sentence. One study has showed that prior record had its greatest effect on sentencing for less serious offenses. When the crime is perceived as less serious, it is more tolerable for other factors to contribute to the sentencing decision. Sentencing is the focus of considerable debate. Liberals argue that sentences handed down are unfair. Conservatives tend to argue that sentences are too lenient. Sentences are expected to be fair, consistent, and unbiased. Discrimination refers to illegitimate influences in sentencing, while disparity refers to inconsistencies in sentencing. Sentencing discrimination studies focus on extra-legal variables such as race and age, gender, and nationality. Studies often contradict one another, and they involve race as the most provocative of these variables. Legal factors appear to be more important, but race does play a role in some sentencing decisions, but there's really no clear conclusion on how these extra legal variables play into sentencing discrimination. Sentencing disparities examine the characteristics of the sentence itself. Researchers focus on geography. In other words, are sentences the same across areas and judicial attitudes? Do all judges in an area give the same sentence? Significant variation occurs in sentencing patterns across jurisdictions, leading to the geography of justice. But which judge hands down the decision also counts. Numerous studies have shown that judges have different sentencing tendencies. Some are known for handing out stiff penalties, others appear more lenient. One study found that federal judges appointed by Democratic presidents were more likely than Republican appointees to decide in favor of the defendant. Proposed solutions for more crime is often tougher sentences. Increasing the severity of the penalty through minimum sentencing has been a common theme in criminal justice policing. More severe penalties result in increased prison populations. Increasing prison populations is not without cost. Minimum prison standards must be met, and the cost is about $70,000 to build a single jail cell and $20,000 to $25,000 to house a prisoner for any given year. States are finding it difficult to finance prisons, and this contributes to the pressure to reduce prisoners early through parole. Sentencing guidelines concern over the fairness and severity of sentencing, and it has led to major changes in part of the criminal justice system. Historically, sentencing was handled by judges and with input from the courtroom work group, and they had tremendous discretion. Over time, however, legislatures have gotten more involved, and reduce judicial discretion and require more consistent application of sentencing parameters. Statewide sentencing guidelines require the judge to hand down a particular sentence based on any number of variables, but including the severity of the crime and the defendant's prior record. There are two general types of guidelines: voluntary guidelines, which provide general guidance, and mandatory guidelines, which state what sentence should be imposed. If a judge goes outside those guidelines, they must provide justification. The same pressures at the state level contributed to the development of federal sentencing guidelines in 1987. They have proven to be very controversial, and many courtroom actors have resisted their application. In fact, the United States Supreme Court in 2005 greatly altered how the federal guidelines are used in the case U.S. v. Booker. The first part of the opinion says that Congress had given too much authority to judges to make factual decisions in sentencing. The second part of the opinion allowed federal judges to continue using the guidelines as advisory. The short and long-term impact of Booker is unclear as the Congress and federal courts determine the consequences of the decision. Let's talk for a moment about the death penalty. Capital punishment, or the death penalty, is the most controversial form of punishment in our criminal justice system. Only a handful of offenders face the death penalty, but the number of persons serving a sentence of death has increased consistently since 1976, when the Supreme Court declared the death penalty constitutional. Opponents believe it is discriminatory. Supporters claim that it is a deterrent. Capital punishment must be consistent with the 8th Amendment of the United States Constitution, which prohibits cruel and unusual punishment. The Supreme Court has heard many death penalty cases setting standards and procedures. In particular, Furman v. Georgia in 1972, the Supreme Court declared the death penalty unconstitutional as a matter of law. However, in Gregg v. Georgia in 1976, the Supreme Court declared state death penalty laws constitutional if they have a bifurcated trial. In the first phase, the jury must consider the guilt or innocence of the defendant and decide unanimously the defendant is guilty. During the second phase, the jury must consider whether to hand down the death penalty and consider aggravating and mitigating circumstances. In both cases, the jury must be unanimous. There is considerable variation across states in how this plays out. 38 states and the federal government have death penalty laws. The Supreme Court has continued to decide cases that impact the imposition of the death penalty. For instance, mentally retarded persons may not be put to death, Atkins v. Virginia, 2002. 18 is the minimum age for executions, Roper v. Simmons, 2005. And charges of racial discrimination appear frequently in debates about capital punishment. African Americans have traditionally been overrepresented among death penalty defendants, but other analyses have shown the importance of legal variables in those cases. The primary relationship of the offender is an important factor in sentencing. This table shows the prisoners on death row have increased until the year around 2000 and then have declined all the way through 2013. Approximately 3,000 prisoners are currently serving a death sentence. The preponderance of these prisoners are held in the southern United States. They are universally male, around 98% are male. The majority are white. Racial minorities are overrepresented relative to racial minorities' representation in the broader public. 48% never completed high school. The median age is 60 years of age. And 11 years is the average wait between the sentence and the execution. In conclusion, public debate about getting tough on crime is always ripe and active in our public discourse. The courtroom work group, however, is very important in maintaining order and decorum in the court and working together to find reasonable sentencing. All actors consider the costs and benefits of going to trial in a criminal case. Sentencing has changed over the years. Today, judges have less discretion than they used to have with mandatory and guidance sentencing guidelines. The death penalty, in particular, continues to be controversial, and the Supreme Court continues to be involved in its application in the United States.